In this video, I'll explain what it means that Florida just legalized cryptocurrency in business contracts and what every business owner in this state needs to know right now. And by the end of this video, you'll learn exactly how this new law works, what it changes about the way you do business in Florida, what risks you face if you ignore it, and the 3 steps you need to take today to protect your company. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. And if you run a business in this state, what I'm about to share with you could completely change the way you write contracts, accept payments, and protect your assets starting today. All right, let's dive in. Here's the thing most business owners never knew was a problem. Before this law, if you wrote a contract that said your client could pay you in Bitcoin or Ethereum, Florida courts had no clear framework for enforcing that. There was no legal standard for what it meant to own, transfer, or accept a digital asset in a business transaction. Some judges were guessing, lawyers were guessing, and business owners that were just hoping nothing went wrong. But here is what you were actually doing every time you accepted crypto in your business without a proper legal structure. You were handing the other side every tool they needed to walk away from the deal. Florida has now updated its Uniform Commercial Code, what lawyers call the UCC, to include digital assets under a new legal category called Controllable Electronic Records. This is the Digital Asset Recognition Framework, and it is the most important commercial law update in Florida in a generation. What this framework does is give cryptocurrency, Bitcoin, Ethereum, stablecoins, NFTs, digital tokens, the same legal standing as any other form of property in a business contract. That means when you put crypto in your contract, Florida courts now have a clear, codified standard for what ownership means, what a valid transfer looks like, and when the transaction is legally complete. Now think about what that actually means. It means you can now write a contract that says a client pays you in USDC, a US dollar stablecoin, and if they refuse to pay you, you go to court and you win. The law is behind you. Before this, that was a very uncertain outcome. Now, it's certain. But here's the most part people are missing entirely, and this is where it really gets important for your business. The reason this law changes everything is not just about whether you accept crypto. It is about the enforceability of your entire contract. Under the new framework, the moment a digital asset is transferred on the blockchain and your contract documents that transfer correctly, the transaction becomes what the law calls a perfected transfer. That word, perfected, is a legal term of art. It means your interest in the assets is now protected against third-party claims, bankruptcy proceedings, and yes, even government seizure in certain circumstances. You're probably thinking, okay, this sounds technical, but what does it actually mean for me? Here's the practical answer. It means the contracts you're using right now, if they say anything about crypto payments, digital asset transfers, or blockchain-based transactions, may already be legally deficient under the new standard. Not because they were wrong before, but because the law has now raised the bar. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. Stop using generic templates for anything involving digital assets. I'm going to say that again. Stop using generic contract templates, because here's what happens when you do. Generic templates do not address the key provisions now required under Florida's updated commercial code. They do not define what a controllable electronic record is in the context of your specific transaction. They do not specify which blockchain, at what block height, and under what wallet authentication standard the transfer is considered legally complete. And they do not include dispute resolution language that accounts for the irreversibility of blockchain transactions. The reason this matters so much is that the party with the better drafted contract wins. Not the party who is right, not the party who acted in good faith, the party whose contract actually addresses the law that now governs their deal. And right now, most business owners in Florida are walking into transactions involving crypto with contracts that were written for a legal world that no longer exists. Now, here's where the law gets even more powerful and honestly, more exciting. Florida's updated framework also creates legal recognition for what are called smart contract transactions. A smart contract is a self-executing agreement written directly into code on a blockchain. When the conditions are met, the contract executes automatically. No middleman, no delay, no dispute about whether payment was made. The reason that this is a game changer for Florida business is that your smart contract can now be enforced in a Florida court the same way a traditional agreement would be. Licensing deals, real estate transactions, service agreements, joint ventures, all of these can now be structured on-chain with full legal backing under Florida state law. But, and this is a critical but, a smart contract is only as enforceable as the underlying agreements that govern it. The code executes, but what the code means and whether it reflects a legally binding meeting of the minds is still determined by a judge applying Florida contract law. So the smart contract and the traditional legal agreement have to work together. One does not replace the other. So here's what you do. 3 steps. And then you do them in this order. Step 1 is a contract audit. Every contract your business uses that touches a digital asset, whether that is a payment term, a token issuance, an FT license, a crypto earn arrangement, it needs to be reviewed against the new UCC framework. Not next quarter, now. Step 2 is what I call digital asset clause stack. This is a set of specific contractual provisions, definitions, transfer mechanics, dispute resolution language, and governing law clauses that are now necessary in any Florida business contract involving cryptocurrency or blockchain transactions. Your attorney should be building this into your standard agreements today. Step 3 is making sure your business entity structure is aligned with how you hold and transfer digital assets. The way you hold crypto in your business, whether inside an LLC, a corporation, or a personal wallet, has significant legal and tax implications under this new framework. The structure that worked before may no longer be the right one. Florida is now one of the most forward-thinking states in the country when it comes to digital asset law. That is a real competitive advantage for Florida businesses, but only for the ones who move fast enough to use it correctly. The ones who wait are the ones who will end up in litigation over contracts that should have never been in dispute. If you have questions about how this law applies to your specific business, drop them in the comments below. I read every single one. And if you found this video valuable, please like and subscribe to this channel because every single week I bring you actionable Florida business law that you can actually use to protect and grow your company. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.